Well, good morning, ladies and gentlemen. We will start our hearing. Welcome to the meeting of Tax 3 Committee. Well, in parallel, there is a still vote going on in Econ Committee, and as we share some members, they have to be still there, but we don't have time, we must start. Our today's topic is combating money laundering in the EU banking sector, and our hearing will consist of two parts with a series of presentation by our guest speakers. Well, as you know, we will speak also about the issue of Danske Bank, so we will touch the core of the matter of anti-money laundering within the EU. And in this committee, we've been following the Danske Bank scandal and fight against money laundering in a very systematic way. We had already a public hearing on Danske Bank in spring, and there will be a mission of the committee to Estonia and Denmark for the very same reason in the beginning of February next year. So also I would recall, as the mandate of this committee is quite broad, that there will be a mission of this committee tomorrow and the day after tomorrow to the Isle of Man. But coming back to today's hearing, the first part of the hearing will be divided in two separate panels. In the first one, we will hear Mr. Howard Wilkinson, whistleblower who work at the Danske Bank, as well as Mr. Stephen Kohn, who is Mr. Wilkinson counsel and expert on whistleblowing protection. In the second part, we will talk with financial and banking experts and representatives. And finally, in the second part of the hearing, in the third bit, we will exchange views with the European Banking Authority and the European Commission on the cooperation between anti-money laundering and prudential supervisions in the European Union. So now I would like to welcome Mr. Howard Wilkinson, and I'd like to thank him very much for being here with us today. You know that he had a demanding hearing at the Danish Parliament 2 days ago, and I appreciate very much his activities and his presence here. So he'll be so kind to provide us with his introductory remarks. Mr. Wilkinson, the floor is yours.
Thank you, Mr. Chairman. Money laundering doesn't recognise borders. And so what better place to talk about money laundering than in the European Parliament, where your whole focus is on coming up with pan-European solutions. In the case of the Danske Bank scandal, this €200 billion scandal, there were at least 10 banks involved. It wasn't just about Danske Bank in Estonia, not even about Danske Bank in Denmark. There's a whole load of banks that were involved, and a lot of banks from European countries. Within Danske itself, suspicious money moved through the operations in Lithuania, in Estonia, of course, but also in Denmark. If we take the left of the slide, the money typically started in Russia. Well, there were some Russian banks through whom the money moved, but there was also the Russian subsidiary of a European bank. There was also the Russian subsidiary of a US bank. We're seeing the European connection even within Russia. If we take to the right-hand side, where the money goes out, we see two large American banks through whom the dollars moved, but we also see the US subsidiary of a European bank. And it's important to stress these correspondent banks in the United States. In my estimate, 80 to 90% of the money that went through Danske Bank ended up in dollars, leaving through US correspondent banks into the financial system. So the banks in the US, including the US subsidiary of a European bank, were basically the last check. Once the money got through them, It was out, clean, and into the global financial system. So we've got all these banks, but we don't really know very much about what the banks actually did. Perhaps we know a fair amount now about Estonia, but let's take Danske Bank in Denmark. According to the Danish FSA report, there were some payments, but they were only technical in nature. The question is this actually true? Because there were people from Estonia, people talking to people in Denmark multiple times a day regarding transactions. Is that only technical? Let's talk about Lithuania. Now, I was told in January 2014 that Danske Lithuania was not allowed to have non-resident customers. And yet it turned out that in 2012, a British Virgin Islands company, which to me sounds quite non-resident, sent over $100 million through a US correspondent bank into the account of a customer of Danske Estonia. Now, this customer was subsequently kicked out because of money laundering problems. It does raise the question why, if Lithuania branch was not allowed to have non-resident customers, firstly, it had non-resident customers, because that wasn't the only one, and second, it had managed to pick up such a bad one. But we hear nothing about that. Russian subsidiary of European Bank. Was it interesting because the feedback from the customers was that they were very pleased when this ruble correspondent bank account was opened, because if we go back to this slide, apparently the two large Russian banks were actually rather strict regarding payments, according to the customers. But the Russian subsidiary of the European Bank had, let me say, a rather relaxed approach to checking documentation. US subsidiary of the European Bank, 9 years, at least 9 years it took before the account was closed. For the first US bank, 7 years, at least 7 years. And even the second US bank, which only opened a correspondent account after the first US bank had exited, took 2 years before they woke up to the problems and closed the relationship with Danske Bank. So what we see is that the scandal touches 8 EU countries and the US. That's 8 EU countries just in the first wave. That's not taking into account that probably money went to every single EU country. We've got Estonia and Denmark, Lithuania, we've got the US, and we have the home countries of the two European banks, the home country of the bank with the Russian subsidiary and the home country of the bank with the US subsidiary. In my view, just as important and just as culpable are the countries where there are shell companies implicated in the schemes. Denmark, and those of you who heard the Danish hearing on Monday, we talked about KS's, which is a limited partnership structure in Denmark that was being abused. The bank's report found, I think, 54 such companies, and they were all suspicious, every one. I actually reported them to the bank management. It was ignored. But clearly the worst of all is the United Kingdom. I think one has to be political, has to be slightly polite when one comes to an institution like this, but one doesn't have to be polite about one's own country. The role of the United Kingdom is an absolute disgrace. Limited liability partnerships and Scottish liability partnerships have been abused for absolutely years. Some enterprising journalists in the United Kingdom found an example of a company. Actually, it wasn't an LLP, it was just a normal, regular, limited company. Now, this company had a director. The director had been born, got married, and become a director of the company within 3 months. Pretty good going. There are also countries in which parallel schemes operated. One customer I met, who was subsequently implicated in a suspicious activity, told me that they were carrying on the same business in Latvia. And a colleague who visited customers in Moscow was told that similar stuff was going through the Czech Republic. And I want to just give a few little mini case studies, because the role of the regulators has been very important, not necessarily in a very positive way. Regarding the Danish FSA, let me give you, on the left of the screen, an extract from an internal email. This internal email was sent by a senior manager in Danske Bank, and it read, "The FSA has helped the bank in a critical situation." Now, if a senior executive in the bank thinks that the Danish FSA has helped them, I think it's a pretty fair bet that the Danish FSA did actually help them. And that raises the question, is it the role of the FSA to help banks, to help the largest bank? You've also you've got some other questions. Would they have helped the Swedish subsidiary of would the Swedish subsidiary in Denmark, would they have helped the Swedish subsidiary in a critical situation? Or was it only the largest bank in the country? There are some real issues also about fairness. The second quote, I can't unfortunately name the people, but what I'd say is that the second person was not an official from the Danish FSA, and the first person was an official from the Danish FSA. These comments were reported to me in January 2015. January 2015 was before any of this really blew up, so I don't think there's any reason to doubt, well, why would this person make this comment up to me? Why would he make it up and tell me? So what he said was, the official from the Danish FSA said, I don't care in the slightest what happens in Estonia. My job is to protect Danske Bank. We're seeing a theme here, help and protect. Does this comply with EU law? Is this what you expect from regulators? Let's move on to the Estonian FSA. And the Estonian FSA was almost like two FSAs. There was one FSA starting in 2014, which was very active, and there was one before 2014. And we've got one particularly terrible example here. On the 7th of April, we learnt that the Estonian FSA had contacted the Danish FSA again, it had happened before, about, in this case, blacklisted Russian customers. And the Estonian FSA had said that they'd contacted the bank twice, but they had the impression that the bank in Estonia didn't take the issue very seriously. That was on the 7th of April, but something magical happened in the next 3 weeks, because by the 25th of April, in an agreed minute between the Estonian FSA and Danske Estonia, now we find that there's been cooperation that's been effective and constructive, and there are no reproaches. I don't understand what happened in those 18 days. Let's look at the role of the Estonian Financial Intelligence Unit, the Estonian FIU, and I think this is a particularly shocking example of failure. This example relates to a company I'm going to describe as A. So in June 2012, A opened an account in Danske Estonia. In February 13, the company was reported to the Estonian FIU. In July, it was investigated by the FIU. Now, investigated was the bank's word. I take that to mean that the Estonian FIU came and asked a lot of questions. On the 18th of July, the FIU came and asked more questions. On the 25th of September, the company closed its accounts, but the owner just set up some new ones. And in April 2014, when I left, 4 related companies still had accounts open. But there's something missing here, because on the 19th of July, only 1 day after the inquiry, the company filed accounts with UK Companies House that were definitely false. Definitely false. So why didn't the Estonian FIU figure that out? All they had to do was look on the website. All they had to do was ask the UK authorities to help them. Finally, to talk about non-disclosure agreements. As has been kind of well reported, I signed a non-disclosure agreement which prevents and has prevented talking to the authorities without the permission of the bank. This is it. You don't see them very often for one very simple reason. If you look in the bottom right-hand corner, they're secret. So there's a number of very important issues here. You see it's not all that short. I, of course, had legal advice, had legal advice on this at a later date after I signed it about what it actually meant. I can't tell you what the advice was, but what I'll say is that in mid-2015, my understanding of the legal position was it might be enforceable in preventing me talking to the authorities, but it might not. And as a private citizen, I can't take the chance. I will only report if I know that I'm 100% safe. To conclude then, I would suggest there are the 4 key issues. First issue is it cannot be right to have NDAs that prevent disclosure of wrongdoing, and you should try to find a way to ban them. Secondly, and as well covered in the draft report, the very deep and intelligent draft report, we're talking about preventing the use of shell companies that are established in EU countries. Thirdly, and very importantly, is a new model for regulation that removes the obvious home country bias that we see in these cases. In the case of Denmark, it's not so much soft touch regulation as affectionate caress regulation. And finally, I would suggest that the committee should make recommendations as to how to protect whistleblowers. I apologise, Mr. Chairman, for massively overrunning my time. Thank you for your attention.
Thank you, Mr. Wilkinson. I think it was worth of it. Your information, although alarming, are highly appreciated. And I'd like to remind members and the public that the slides provided by Mr. Wilkinson you've just seen will be on the Tax 3 committee website after today's meeting. I'd like now to ask Mr. Kohn for his intervention. Up to 7 minutes, please.
Thank you, and thank you for this opportunity. The issue about protecting whistleblowers has nothing to do whether you like or dislike whistleblowers. That is no longer the question. The only issue is whether you want to effectively combat fraud and corruption. If the answer to that is yes, it has now been demonstrated that you absolutely must incentivize and utilize whistleblowers. And the reason is obvious. You've heard from Mr. Wilkinson. You need an insider. Money laundering, tax evasion, foreign bribery. These crimes, unlike murder, where you may see the victim, these crimes are hidden. The crimes are effective if no one knows they happened. Without an insider, you can't even know there's been a victim. In the United States in 1986, we modernized an old qui tam law that was passed by Abraham Lincoln at the time of our Civil War, and the rule was very simple. Incentivize whistleblowers. If the whistleblower's information triggers a successful enforcement action, then you give them a reward. If it doesn't, you give them nothing. And the reward only comes from the monies paid by the corrupt entity. Cost the taxpayers nothing. It was an experiment. An experiment. One that we can all learn from now. Because after 32 years, our government officials responsible for this program have concluded that this law to detect fraud is the, quote, most powerful weapon. And I call your attention to the word most. It's not that the whistleblowers are helpful, or it's good to hear from a Mr. Wilkinson once every 10 years. If you have a real program, the whistleblower who detects the hidden crime becomes the most powerful tool. So the question before the European Parliament is whether you want to implement the most important tool to fight corruption or continue letting money laundering fester until it's a $230 billion scandal. The proof that the False Claims Act works is in dollars and cents. Because the whistleblower must be compensated, the United States government has to calculate all of its fraud cases. Did the fraud come in from a whistleblower, and we have to give them a share, or did we catch the fraud, the government, through the inspector generals, contracting agencies, the entire bureaucracy that's designed to detect fraud? Which way did it come from? Well, after 32 years, in 2017, guess what? 92% of the fraud recoveries were brought in by whistleblowers. The government bureaucracy, which I fully support, to detect crime and fraud, brought in 8%. So when these officials say it's the most important tool, that's backed up by solid empirical evidence to the penny. This chart just shows you how it worked since 1986 when the law was modernized. It just keeps going up as they calculate how much money is brought in by fraud. And since '87, when the first cases were filed, 72% of these cases came in from whistleblowers. And this is just another way, this is just the Department of Justice figures validating it all. Essential tool, numerous quotes. Interesting part is that the United States law and whistleblower laws are transnational in application. My last count is over 2,500 non-U.S. citizens have filed under the SEC, our Securities and Exchange Commission program alone, most from Europe. These are thousands of whistleblowers who do not have adequate protection in their home countries coming to the United States to use these laws. They have been paid millions in compensation. My favorite is the IRS tax law. It is the most incredible whistleblower success. I do not know how many parliamentarians are aware that every known U.S. illegal, undeclared account in Switzerland was closed. Almost, I believe, every bank came in and cut a deal. Over $16 billion collected in fines and penalties. Why? Because the bankers obtained protection under U.S. law, and it became more profitable for a banker to turn in their U.S. clients than to service them. An incredibly effective law that in 2018 was amended to cover money laundering. This is a model. This is the law you should implement for tax evasion, money laundering, and securities fraud. This is just an example of the countries in red, or all the countries in which whistleblowers have come into the United States to file anonymous and confidential claims under the Foreign Corrupt Practices Act. Alone, just the Foreign Corrupt Practices Act, because we have effective legislation. This is a quote from the head of the Securities Exchange Commission at the time she was the head. And it really sums it up because you hear it from Mr. Wilkinson. That's why his testimony is so important. A force multiplier, that's the whistleblower program, generating high-quality tips, and in some cases, virtual blueprints. That is what you can get through an effective program. Thank you very much.
Thank you very much, Mr. Kohn. Okay, there will be exchange of views with the members now. As always, questions and answers will be done in 5 minutes. A question of maximum 1 minute with the remaining time devoted to the answer. So first, Ludwig Niedermayer, co-rapporteur for EPP. The floor is yours.